Lucas Weber, Deputy Counsel at the Wisconsin Institute for Law and Liberty, joins us now on the Middleton Ford hotline. Middleton Ford, family-owned and your good neighbor Ford dealership for 75 years. Boy, there's a lot of moving parts in there, Lucas. We always appreciate your expertise and your perspective. Thanks for joining us.
Yeah, thanks for having me on. Good morning.
Yeah, good morning to you, and I would assume you are not altogether surprised by this lawsuit. You are not altogether surprised by this ask by Mark Elias and his group.
Yeah, this is, and that's correct. This is exactly what we expected to happen, because this is exactly what they said they would do. The partisan campaign officials who were pushing this message before the election spun this race into really a fight for congressional maps, and it's no surprise now that after that race is over, they bring this case. That said, it's certainly not a slam dunk, as we've put out a memo explaining some of the issues with the legal claims, and it'll be something to keep an eye on as it moves forward.
Yeah, it's very important. In fact, you can find the story at thefederalist.com. We put together something a few weeks ago, and I had a chance to talk to Lucas on this, but a great analysis into, while there was a good deal of talk, this became a central focus of the Supreme Court race concluded last month. The likelihood, you would say, Lucas, of this actually succeeding, where does that stand? And tell us why, if you will.
Yeah, for sure. So this new action was brought as what's called an original action with the Wisconsin Supreme Court. So they filed a petition asking the court to take this case. And then once they take the case, they want to declare Governor Evers' maps unconstitutional. And then, presumably have them redraw the maps in a way that benefits their chosen candidates. So they brought those claims under the Wisconsin Constitution before the Wisconsin Supreme Court. But the Wisconsin Supreme Court is not likely to be the final arbiter of this. And that's because in the U.S. Constitution, there's what's called the Elections Clause. The Elections Clause vests the power to draw congressional districts in state legislatures. Now, courts have obviously recognized over the years that courts have a role to play when legislatures can't do that. Just like in Wisconsin, where the legislature and the governor couldn't agree on the maps, courts have a remedial role to play to step in early in the decade and correct the population differences between the districts and redraw maps. But the problem is, and in the Supreme Court, the United States Supreme Court has warned state courts of this, is what happens when you go beyond kind of traditional judicial review. So when you actually try to usurp that legislature's role, and this type of mid-decade redraw of a state maps for congressional districts is exactly what the United States Supreme Court warned state courts from doing. So.
And that's interesting to me. Lucas Weber, Deputy Counsel at the Wisconsin Institute for Law and Liberty, joins us now to talk about the expected, if you will, in politics. Democrats want the left bought and paid for Wisconsin Supreme Court to take up new congressional maps. They don't think it's fair. And it's funny they don't think it's fair because their standard bearer in the state of Wisconsin, Governor Tony Evers, signed off on these congressional maps, which is perhaps a complication here. All of that said, we know the politics driving this, but the Wisconsin Supreme Court has rejected a similar move under a liberal majority in the not too distant past. Do you believe there is the possibility that is maybe as highly partisan as this left-wing led court is, they will stick to their original decision from a year or so ago?
Yeah, it was, as you know, just a little over a year ago, the same law firm actually brought basically the same claims to the same Supreme Court, which rejected them at the time. And it would certainly not surprise me if the court did that again. But again, even if the court were to take this and move forward, it is still certainly hanging out there that the United States Supreme Court would be kind of the final backstop on this and be able to review whether such an action, an extraordinary action, frankly, by a state Supreme Court would be constitutional under the U.S. Constitution. So, A lot of moving parts here. It'll be certainly one to keep an eye on, and we will absolutely keep your listeners in the loop as it moves forward.
I appreciate it, and I know that Vicki will be very interested in following the story and very interested in Will's expertise on this. Let me ask you the kind of question that attorneys, particularly constitutional law attorneys, get a little bit uncomfortable about. Okay,
yeah,
and it is this, because it's the political side of things. If the Wisconsin Supreme Court, maybe under Susan Crawford, maybe under the current regime with Ann Walsh Bradley, who Susan Crawford will eventually replace this summer. If they do take up this case, what does that look like for the political optics? Does that not drive home the point that was made during this election that this is a leftist bought and paid for court?
Yeah, I mean, I think it's certainly the optics of it would certainly feed into that narrative, absolutely. And I think there'd be some concerns, and I'm certain that there would, some of the litigants, and we're not even knowing yet who all the parties would be in such litigation. There'll certainly be interveners involved, and then whether somebody tries to file like a recusal motion against one of the justices if they take the case. And again, they haven't yet taken it, but if they take it, it's certainly possible. Somebody could even file a recusal motion prior to them even considering the petition for an original action, and those are things that the court will have to decide. And yeah, it'll be something to watch going forward. Absolutely.
Final question for you: there is a timeline here. The court can act the way it will act at any time. It will decide. It's up to its discretion. But is there kind of a set timeline and when this thing will have to be resolved? Because before you know it, we're into campaign season for 2026.
Yeah, that's a great question. Yeah, there is. So it really starts once candidates have to start circulating nomination papers for the 2026 fall elections. So that'd be in spring of 2026. I believe it's April 15th, I think, is the date that those nomination papers go out. It doesn't necessarily have to be done by that date, but I think that's probably the date that everybody would circle as the, sometime before then, trying to get things done just so candidates would know what the maps are. But again, that timeline is really, the litigation could go any number of places if they do grant the petition, and United States Supreme Court review could add kind of another wrinkle to that whole effort.
Indeed. I find it rich that the nomination papers for congressional candidates due on tax day.
I'm pretty sure they begin to be circulated that day. I think that's what it says.
It's circulated. I never put that together, but very timely, very, very timely. Well, Lucas, I do appreciate, as always, the expertise, your perspective. You can read more about this, by the way, at the Wisconsin Institute for Law and Liberty. Lucas did a great analysis of it. We covered it over at the Federalist, too. You can find it there on all of the turning wheels in this. Again, thanks for sharing your time and your expertise this morning.
Thanks for having me on, Matt. Have a great day.